think that non-resident parking means you're not an employee in this building, you can park there.
Well, as a matter of fact, sounds like we can get in there.
Instead of powering off, there's something else we can do to mute this.
Usually holding down your volume, you know, doing the volume all the way down will put you into vibrate mode or that, so it doesn't ring, or then see it says like the minus there, which is kind of the quiet there, and that's by just turning the volume all the way down.
Okay, I just turned it off.
I mean, turning it off certainly is foolproof, and there's other things that can be done. These calls you'd let through and ring and things like that. But
yeah, there's apps that can help you do that too.
That is a motor, right? The motos have that nice assist, but it's a moto thing. It's not an Android. Android should have that where I'm in a
I probably have that
automatically switch
right.
to the
Yeah, you can
vibrate only.
vibrate. Yeah.
Set it up. That's a nice answer.
Okay, we'll get started. Hopefully, some of the other people that may be trying to find a parking spot or that will find a spot and join us. But our main topic today will be legal software and sites, and I'll be presenting. I'm Kreuzer. Before we get there, we'll do a little club agenda stuff. Future meetings. Our next meeting will be back in the Caribbean room. We got bumped from the Baltic this month because of some other event down there, but as I've said before, we're having trouble getting our room because they won't let us reserve ahead of time, and then we can get bumped. So we just kind of have to make the best of what we can. But our next one will be June 21st. We'll be talking about selecting a tablet. So we'll talk about some of the features and things to consider there. The next Max SIG is June 19th. And if you want to put this on your calendar, we now have a date for our picnic. It'll be July 17th from 4:30 to 6:30 back in Battle Creek Park where we were last year or the last couple of years. Our officers, Jim Holman here is our president, Linda Brown is our vice president, Paul Ebert over here is our membership secretary, Mike Griffin is our treasurer and MaxSig, Stan Miller and back there is our secretary, Andrew Petrucci is our communication coordinator, and I'm Tom Kreuzer, I'm a director at large. Members old and new, you can pay your dues to Paul. Reminder, if you are changing your emails, whether retiring or changing your provider or whatever, make sure and notify us because that's how we send out these notices and other things. Suggestions for topics, you can email your topics, talk to any of the board members. We're always looking for people to volunteer, present. Could be on something that you do at home or at work. And if you don't want to present, we do have a monthly eBytes newsletter. You can write a short, meaning a sentence or two, or long, multiple pages, review of or comments or something that you're interested in there. Website has available out there our past meetings, slides, and handouts, and when we record them, that's also out there, so you can find that. We do have a deal section, and our monthly newsletter is out there. And the site is listed on the back of the handout. If you don't have a handout, I think Jim put some over here. Any club questions before we get to the main topic? Okay. Okay, our main topic today is legal software and sites by myself, Tom Kreuzer, and an estate plan is one of the most important ways to protect you, your children, your loved ones, your health care, and your finances. Recent surveys showed that only 60% of us have done it. So a lot of us keep putting it off or think we don't need one and don't end up doing stuff. You can pay an attorney, or you can use software, you can use online services, or you can even fill out paper forms. So there's a lot of different options that you can use. The software and sites are just like kind of the tax software that we have now, where they ask you questions and then they generate completed forms that are in some cases state specific. So just like years ago, most people weren't doing their own taxes. They took it to a tax accountant or a H&R Block or someplace like that. Now a lot of people are doing their own taxes, and you can do that with your estate planning also. So gives you some options there. You can write your own simple will in less than an hour, and the cost can be anywhere from zero, because we'll talk about some free options that are out there, up to about $100. That's compared with about $800 to $1,000 to have an attorney do a simple will. Again, if you have more complicated and lots of talks or things like that, your attorney bill is going to be much higher there. Okay, what are some of the steps that you should do right now? Well,
Tom, can you elaborate on that last statement?
Sure.
When should I pay the $1,000 for the attorney, and when should I not?
I'll talk about some tips there on when you might want to talk to it. At a minimum, what I'd recommend is that you start to do it yourself. And when you start to do it yourself, there's a number of resources that we'll talk about, but it'll step you through of the basic questions. So even if you start the process of doing it yourself and start figuring out some of these answers that you want, by the time, if you do decide that you want to go to an attorney there, you're going to save yourself some time and money, because you're going to be able to tell them this is how far along you got, this is what you did, what your thoughts are, and you've collected all the information.
So you would do it yourself and then send that document to the attorney.
If you feel that you need it, if you have complex situations, and we'll talk about a few of those complex situations that you might want to do, but for most people, you don't need an attorney. And for the will, we're talking for the will. For these other documents, power of attorney and healthcare directive and things like that, you usually never go to an attorney for that. But for the will, certain situations, you might want to consult with an attorney there. But again, for most people, kind of like the taxes, can most people get by with online? Yes. Could a Donald Trump get by with online? No. You know, for a number of reasons. Yes.
I had one of those expensive wells done 20 years ago. And a couple of big benefits. One is every 3 years you got prompt from the attorney if you want to make any changes. Are there any legal law changes that affect you? And you're encouraged to take a hard look at your beneficiary designation fairly frequently, because that is the big issue.
And we'll talk about beneficiaries, and I'm glad you brought that up. The changing of a will or that, certainly you want to, let's say you get divorced, or the executor dies that you've designated. You want to keep on top of these things and make sure that everything's as accurate as possible. Now, my argument would be, okay, I actually do this stuff all myself. I haven't paid an attorney and that. And so for most of my family, they've used what I've used there. Reminders, put a reminder in your calendar. If you want to be reminded every year, you can be reminded every year. It's just one of those things that, yes, you shouldn't just let it sit and not keep it up to date.
Never.
Right, and we'll talk about some of the things there too, trusts and beneficiaries, because if you have beneficiaries set up in a number of your accounts, that doesn't go through the will at all. So right away, you're maybe taking this bigger pot, and you can narrow it down to these are the things that have to go into the will. The rest can be handled either with a trust or with the beneficiaries, that it's not going to have to go through probate. It's not going to have to go through the will. So there's ways of doing, but certainly for more complex things, talking with an attorney or that can be beneficial. There's a ton of books out there. There's a ton of online stuff and resources that'll step you through stuff too, and identify, oh gee, maybe you should talk to an attorney about this. If you're going to have conditional things in a will, which you'll see later, I don't recommend, you want to get that set up right. That's probably going to take an attorney to do. Yes, Dan.
Depending on how engaged your spouse wants to be in what you're doing and what your differences of opinions are on one matter or another, an attorney can help bridge some of that conversation.
Yes, yes. Just sign on the dotted line. Yes.
So someone once told me.
Yes. So you were told. Okay.
Well, in her defense, she doesn't care to be involved in any of this stuff. So it is a way to engage her in the thought process and devote some attention to it rather than say, oh, okay.
Okay, so the first thing you should do in any of this is make sure and create a will. Will spells out how you want to dispose of your assets. Excuse me. How you want to dispose of your silence this here. Dispose of your assets after you die and appoints an executor to carry out your instructions. If you have minor children, your will name the guardian who's going to care for them, which is very important. If you die without a will, state laws choose your beneficiaries and decide who gets what. If you recall, Prince died without a will, and you get this. The lawyers make a lot of money. The family ends up fighting, and that don't be Prince. The cost of software, as I mentioned before, the sites range from nothing to $100 to do your will. So there's, again, no reason not to do this. Also, if you're not familiar, for about $5 to $20, you can go to an Office Max, and they have little packages of ready-to-make forms that you can buy, and you can do it that way too. So you don't have to use software, but you really should use this software because we're the PC club. We aren't the paper club. If we were the paper and stone club, you could get by with just forms. But the software will ask you questions, and it's kind of the equivalent of, do you want to do your taxes by just getting the forms and filling that out, or do you want a software package that steps you through, asks the questions, puts all the right names and the right stuff in the right area. Just a reminder, a will prepared by you is just as legal as if an attorney drew it up. So again, if you're following all the steps that the packages tell you to do and to get the signatures and things like that, it is a very binding legal document. Number 2, consider creating a living revocable trust. Does anyone here, have they set up trusts? Okay. And trusts are very, very good there. In many states, when you pass away, your state may go through a court process known as a probate, which can be costly and time-consuming. Titles to assets, either property or financial accounts, must be changed so that they're owned by the trust. So if you're going to set up one of these trusts, the trust can bypass the probate there and make it a much cleaner process of transferring those to whoever you want there. While you remain alive, you retain complete control of the trust. So anything that you put into the trust, you still control it. You're getting dividends, whatever, from the trust itself. It's only when you die that the trust gets executed and then passed on to the people that you've identified there. With a living revocable trust, you still need a will, specifically what's called a pour-over will. In this document, you name a guardian for your children. You ensure assets that weren't retitled before you pass away make their way into the trust, although you may have go through probate to get there. So you still need that will because maybe you didn't get all of your assets into the trust, and so this is a way to take care of those things that you had forgotten about.
Tom,
Yes.
are you familiar all with deed on death? Which is one of the things you can do with your house, for example. You can actually establish a deed on death, and it'll be executed similar to a trust, but it works a little differently. It's pretty simple, and then you register it with the county, and that takes care of your house, and you don't have to have that go through probate.
Yeah, so that's certainly another way to do this, because if you're trying to make it as simple as possible for everybody and things like that, that's what some of these things can do. And if you know specifically who you want it to, the trust, maybe you're breaking it up by percentage or things like that, there can be options there.
You can do the exact same thing with automobiles.
Yep.
I heard a living revocable trust is ruling beyond the grave. Is that kind of a summary of it?
Yeah, because
And maybe that's a good thing. Could be good, could be bad.
right. You certainly want to keep it up to date because again, if you're trying to make sure that the assets get to the right people there, and if you don't keep it up to date, or if the situations change, people die, more children are born, things like that, you've got to make sure everything's kept up to date there for any of these documents to work right.
But revocable trust, at one point I thought my kids would never squabble on my death, and now I'm not so sure.
What I'll tell people is it's kind of like a divorce. I've helped some people through divorces, and some of the people have said, "Oh, we don't need a lawyer because we agree on how things are going to be broken up." And I said, "That's not how it works. Every couple that I've known has some disagreements, and that disagreement could be on 401ks or IRAs or hidden assets, and you've got to make sure that everything's out in the open and stuff like that. So, it's do the best job that you can in that. But the revocable trust, probate, going through, we were talking before the meeting a little bit about probate and that. And probating an estate, or that, even a simple estate, minimum of probably 1 year, more realistically 2 years to complete the whole process. So if you're looking to transfer this stuff quickly and as inexpensively as possible, the trust can be the mechanism to do that, or the deeds, or some of and the beneficiaries. What we're talking about here with the beneficiaries, that it's imperative that you review your beneficiaries for retirement plans like IRAs, 401ks, Roths, brokerage and bank accounts, and insurance policies. Because usually, if you started at 3M, maybe when you started at 3M, you put down a beneficiary in there. Well, a lot of people haven't updated it since then. And that's not a good thing. So you want to make sure that beneficiaries take precedence over the will. So if you have money in which you should have in your 401k or IRA or that, and you think it's going to get passed percentage-wise to the kids or whatever, but you've only listed your wife as a beneficiary or something like that, okay, that's a problem. Because it is going to take precedence over the will, and if your wife is dead and that, all of a sudden you start opening up complexities there. Yes.
One of the things I remember, actually, I went to a lawyer and got a will. one of the things that he told me is, he said, one of the mistakes people make is they don't name their next of kin on a will, either because the kids came along later or whatever. And he said that's a frequent source of a challenge to a will. So that may open the avenue to problems like you
Right.
talked about, or even a legal challenge to the will, and perhaps even invalidate the will.
Yeah. And nowadays with DNA checks too,
Oh,
you may
yeah,
find that you
yeah.
have children that you didn't know about, or somebody contesting that way too.
Yeah.
So it's
and he said you don't necessarily have to give them anything, but you have to name all of your next of kin as possible beneficiaries and what you want to have happen
Yes.
out of your assets after you die.
right. No, good point there. Beneficiaries, you can usually change those online, so it's usually very easy to do while you're living. But once you're dead, you have a problem there. But certainly make sure that the beneficiaries are up to date and check out your options in each of these. So it's easier to identify that in here than to just leave it blank or say, well, it'll go to my estate and then my estate will determine it. No, make it easy there. Okay, another thing that you should have is a durable power of attorney, DPOA, or sometimes people just call it a POA. If you become incapacitated and can no longer handle your finances, having a DPOA in place will allow somebody you designated, a trusted family member or a friend, to manage your affairs on your behalf. There is no universally accepted format for a DPOA. So unlike some of these other documents in that, they're state specific or formats there. The DPOAs are not. You'll see many different varieties there. Some financial institutions have their own, and you're required to fill that out, even if you have a DPOA in another format there. So just be aware of that. Another thing that you should have is an advance directive, sometimes called a living will. This details the type of medical procedures that you do or do not want, as well as wishes for end-of-life care. So if you don't want to be on a ventilator, which essentially is breathing for you and doing things, you can specify, I don't want to be on a ventilator and I don't want these things taken or done to me there. This document will ensure that your choices are followed in the event that you cannot advocate for yourself. If you haven't thought much about medical care, you can go out to the website, and I listed here the American Bar Association, and if we click on that, again, there's tons of resources for all this stuff out on the internet that'll step you through making the choices. They'll give you forms. They'll tell you how to get this stuff set up and what you can do there. So certainly use some of those. You don't need an attorney to draw up an advance directive. The form is legally valid if it's signed in front of a witness. So all you need is a witness. Doesn't even have to be notarized there. These directives differ by state. You can find the appropriate documents out at, like in this case, this website, Caring Info. You tell it your state, and it'll give you the form that you need for your state. You want to make sure and let your family members know about your advance directive and keep it accessible in the event of an emergency.
So Tom, an interesting situation, if you live in Wisconsin and your hospital is in Minnesota, which do you have to have one for each state? Is that what you're saying?
I would have one for each state because it's where you're going to be serviced. So if you go to Regents Hospital here in Minnesota, you'll want a Minnesota directive. If you do end up in Wisconsin, then you'll want a Wisconsin. Now, so you can fill out as many of those as you want. The other thing we'll talk about in just another second here, choosing a healthcare proxy. Healthcare proxy or a durable power of attorney for health care. So that's you're appointing somebody that you trust to act as your agent in conveying your healthcare wishes, which ideally you've documented in your advance directive. So here you're saying, well, let's say it's a daughter. You have a daughter, and you're identifying her. She's the one who can make the decision to pull the plug on you or to not put you on a ventilator, or that when you can't make those decisions yourself. So again, all these last two things are when you can't make decisions yourself. It's what do the doctors, what do the hospital, who can they trust? And if there is nobody, then you end up with this squabble of here's the family in the hospital, and the doctor's trying to figure out, do we pull the plug on this person?
So that would work regardless of the state that you're dying in.
Yes, a healthcare proxy is giving the power to this person, and then regardless of what comes up, that person is making your healthcare decisions. Yes, we'll go ahead with the surgery. No, we'll do this or whatever. They're the one that does it. Otherwise, the hospital doesn't know who do they. If the wife is still around, then it'd be the wife. But if let's say the wife isn't around, now you have 3 kids or 4 kids. 2 of them are for and 2 of them are against. What do? Do an online poll?
This happened to my neighbor recently. In the case of an emergency, the emergency doctors are obliged or must stabilize the patient independent of what the healthcare directive says. Doesn't really matter. So it isn't until a day or 2 or 3 later, whenever things settle down, before somebody finds a piece of paper that said, oh, they didn't want that and all the rest of it.
Yes, and that can frequently happen. So let's say I filled out a directive saying I don't want a ventilator. When I go into the hospital, if they don't know any better, their first deal is to keep you alive, and some hospitals or stuff like that will do whatever it takes. But then a day or 2 later, hopefully you express these wishes to multiple people. Now they know that you do not wish to be on a ventilator, and then they can tell the hospital this is what the patient really wants done, and then you can do that. So yeah, I wouldn't say don't do it, but is it foolproof to prevent everything? No, but you're best to go through, because again, these documents, hopefully you can fill them out in an hour or 2 hours at the most there, and then let people know, and I'll show you how you can share it and people can have access and things like that. Now you have a better chance of this being done the way that you want instead of being done according to whatever.
Also make sure that your healthcare provider has a copy.
Yes.
They
Yeah. The issue I think that Hal's getting at is, I could give it to my private doctor, but when I go into the emergency room, again, they're doing things that they aren't looking up things at that point. It's only after the fact that they say, oh, gee, we don't see any activity in the brain. Should we pull the plug? Well, then they'll start looking for directives, proxies, things like that on who really has the power to do this. Yeah.
I was going to say, my doctor's office pestered me every time I went in to give them a copy of the living will, so I did, which brings up the question that if you have a copy of that at home, you should probably put a note on who you gave it to, or Line Eye Clinic, Health Partners, or whatever, so that you know if you change it, you have to give them a new copy.
Exactly.
And the other variation on this, when you're talking about that, because of a change of address, I went to the website and made sure everything was changed on there for my address, and then I realized, oh, you changed your address, it doesn't always change the spouse's address on the website. Then I started digging into it and realized it said, oh, I have a son and a daughter. I don't, I have 2 sons. So go through every little nook and cranny on those websites and update it while it's easy to do when you're alive. It's very hard to do once you're dead. I don't be looking for a daughter that doesn't exist.
No, good
There's a
tip.
conflict between the living will and this healthcare proxy. Who rules?
Well, the healthcare proxy is going to rule there because that's who has
As
access.
opposed to living will?
Well, hopefully you've talked about your living will with the person that you've designated as your healthcare proxy. But if there is a conflict, the healthcare proxy is going to take precedence over that. Yes. Right. Yeah, you're going to get in more trouble by not having the documents and then not knowing, especially when there is no spouse and it's multiple children and the children can't agree. Should we go through with this surgery? Well, there's a risk to the surgery, and half of them are saying yes, and half of them are saying no. Well, who has the authority there? You know. Yes.
Does the proxy have the option of a primary and then a secondary? The primary being the spouse, let's say, or secondary being the son or something like that, depending on.
I believe so.
Mine does.
Yeah, I believe they all have that. But again, you want to keep things up to date and you don't want to do things without notifying people. So if they are going to be your healthcare proxy, talk to that person and say, I'm making you my healthcare proxy there. And that don't just say, well, let them figure it out. No, nobody wants to be in that situation because all the kids are saying one thing and, things like that.
The way the secondary proxy works in my case and in my mother's case, I'm real familiar with this because I'm putting her in hospice today, is that I have primary proxy, but if I am unwilling or unable or unavailable to serve as proxy, then it devolves to my brother. And he's also listed in the healthcare directive.
No, thanks for that. You can find out more about the responsibilities of what's involved with the proxy. Again, there's a link out here which offers insight into choosing and setting it up. This is, we talked a little bit about some of this. You better organize your information because it does no good to have this stuff and nobody can find it or nobody knows or has access to it or it's in a safety deposit box and nobody can get to it. So what you want to do is you want to prepare a user manual and share it with your executor right away. Make sure it's in a secure spot and don't tell family members you don't completely trust. So if you have a son or a daughter and you don't trust them, don't tell them where your will is because they may take the original and get rid of it and because they don't like what it says in there. So only tell it to family members and people that you trust. You want to provide a list of all your assets, bank accounts, credit cards, stock accounts, PayPal, life insurance, photos, videos, subscriptions, reward programs, bills, social media, email, attorney, financial advisor, and where to find your original copy of your wills and trust and any deed documents.
Another reason to use a password manager. Because
And I will get to that.
Okay.
And I will get to that, yes.
Very careful to make sure you shred old.
Yes. Yeah, because there's the original copy.
They're in they're copied to the county in which you reside, and so the county may have old copies of the will or whatever. We had to make sure that when we did a redo on our trust, that it went to the county and they shredded the other document.
Yeah, and even if they didn't get rid of it, the fact that you have a new one that is valid, that will take precedence. Right. It just makes things easier to make sure that everything is in line. So when you do make changes, I think it was mentioned earlier, keep track of who you sent some of these documents to so that you can resend documents and make sure that everything is in sync there. Here I mentioned include your list of username, passwords, access codes to your online accounts. Do not put this information in the will, because the will is public information and will be filed, so you don't want all of your accounts and passwords and stuff like that. So this is a separate document or how you organize there. Yes.
In Ramsey County, I filed the will for a friend at the state of Minnesota, but I'm not sure if it was actually required.
I guess I'm not sure.
Is it optional, this public information thing? Is filing a will optional?
Oh, when a person actually dies and it goes through court, that court document, it's a public document at that point. And so if you list before they die, no, it wouldn't be public information before you die, but still you wouldn't want that information even after you die. And it's again, you don't want to complicate the will and cause problems, so keep it simple.
No, it's your question. If I do a will, do I need to file it with the county? Is that your question?
That's exactly what it was. I'm going to pay for it, $30 or something to file with the county. Then it's good for everybody else can go with it. The county knows. And that's assuming one will.
You don't have to. Certainly it can make things easier, but do you have to? No, because it's a case of if I don't file with it and I end up dying, my executor now has my will. They can file that and move forward with the probate and everything with that. So it doesn't. And nursing homes and that, just like the healthcare proxy and stuff like that, they want to make sure that they don't have to. It isn't a problem for them. So again, it depends. And again, if the majority of your assets are set up in trusts and things like that, well then the will is going to have next to nothing to dole out. The beneficiaries and the trusts are going to take care of everything, and the will is going to have next to nothing there. Yes, Jim.
Wisconsin has different rules on death than Minnesota, but you're a resident from Minnesota and you die in Wisconsin. What rule book takes that?
The wills, as far as I know, are not state specific, so they cover the entire United States there. Your estate is going to usually be probated in where your residence is, not where you died. So let's say Prince died, which he didn't, but if Prince died in Atlanta, it's not done in Atlanta, it's done in Minneapolis court system.
Well, one wrinkle on that, there are states that require that your estate go through probate. So I don't know how that works. If you're a Minnesota resident and you're in Georgia, when you die, and Georgia is the state, I know that because that's where my mom died. It's a state where
if your assets are above a certain limit, it has to go through probate.
Well, Georgia is pretty low.
Okay. If you have 2 pigs and a cow, it has to go through. But some states, for a small estate, it doesn't. But certainly for larger amounts, again. But that's
the question.
Yes.
In that situation, if I happen to be down in Georgia and I die there, then do I get forced to go through probate because Georgia says any death, any estate has to go through probate, or would it go back to Minnesota?
As far as I know, it goes back to Minnesota. But I'm not a lawyer.
One of the reasons maybe is because probate, where those are published.
You can usually just do a Google search and you'll find out there. It's best not to even look it up, just because you can file a will for nothing, $0. Do it. Everybody in here should have a will. Put your requests in there. Whether it ends up being executed or not, If it doesn't have to be executed, you aren't out anything. If it does have to be executed, now your wishes are going to be executed. Okay? We'll move along, and if there's other.
Everything's just, we are attorneys.
Yeah. Okay. Jim had mentioned to keep track of the stuff. I use the free package LastPass. LastPass, in addition to storing accounts and passwords, you can also store documents in there. So you can put all of your accounts and your banking information and everything in LastPass, and then somebody you trust, again, this is not, I'm not going to give out this information to somebody that I don't trust, has access to my LastPass, in which case they would have access to everything I'm currently getting into. This I just mentioned here because when I was doing it, I thought this was hilarious. Don't be the guy who locked out cryptocurrency exchange customers out of $250 million after his death because he's the only one who knew the password. I imagine there was a lot of angry people there that couldn't get at their money and will never get at their money because only he knew the password, and that was the end of it. Thing to consider here is, even though you have passwords and stuff like that, a number of the sites and that will require two-factor authentication. So if you do have two-factor authentication set up, your loved ones might need to access your phone. So again, somebody that you trust, setting them up either with their fingerprint or they know the code or stuff like that on your phone is an important thing to do, because again, you don't, if unfortunately I step outside and get hit by a car or a bus and die, you want to make it as seamless as possible to get access to these things, and so you have to take into account what can happen there. Android options vary, but if you do a quick search, you can figure some of that stuff out. Be sure and review and update this information every year or 2 years. So just because you've organized it, good, but make sure that you keep it up to date. Original documents should be kept in a bank safety deposit box or a home fireproof safe. Also, if you do have a lawyer, your lawyer should have the original copy. Here I mentioned this is a website, relatively new website that came out, and it's called Cake. It's for free end-of-life planning website. So it has comprehensive planning tools for healthcare, legal, financial, legacy, and even funeral decisions, and that all in one tool. You personalize the planning checklist with guidance on how to begin and what to do next. Document creation for advanced care plans, funeral plans, and other planning documents are stored there. Document storage for the plans you create on Cake. You either can create the documents on Cake, or you can upload if you're using another package or you're using another site, or you got them from a lawyer. You can still upload documents and put them out there also. It easily allows edits so that you can keep the stuff up to date. It also has profile sharing, and this gets important when you start talking about executors and who has access to this stuff. It allows you to designate loved ones or whoever is going to be executing some of this stuff has access to which documents and which information. So you manage these contacts out there so that each contact knows what they're responsible for if there is an emergency, and then has access to the appropriate documents there. You assign roles so everybody knows who is responsible for carrying out whatever there. Cake makes its money by making recommendations and products and other service. So they are free, but they do make recommendations out there. And let's just, this is, yeah. It's bank level encryption. Yep.
We do our best to care for the ones we love, to live more fully in the present. But that's hard when we worry about things that seem outside of our control, Things like, what will happen at the end of our lives? And will our loved ones be okay after we're gone? But what if thinking about the end wasn't as hard or as scary? That's why we made Cake, to make it easier to get your final affairs in order, to have more peace of mind now. Use Cake for yourself or with someone who needs help planning. A personalized checklist helps you plan for healthcare, legal, and funeral decisions, and other things not covered by traditional estate planning. Cake helps you make decisions by posing simple, thought-provoking questions. Your answers create documents that express your final wishes. It's easy to print them or update them if life changes, which it does. Already have documents? Upload them from your computer or phone. Everything you do is secured with bank-level encryption. Make sure people know where to find your plan. Share access with anyone who has an email address. Get ready to share what really matters to you and make things easier on your family someday. Sign up to create your free Cake plan. Live life fully.
Yeah, and there is no paid level, so it's not like they're trying to sell you another level. This is kind of the equivalent of Mint, if you're familiar with Quicken Mint for managing budgets and money and bank accounts and stuff like that. This is the equivalent of that for estate planning and that. So ton of information out there, ton of links out there. Certainly, I'd highly recommend starting with that.
Does it do everything, including steps 1 through 7, basically?
It can, but again,
You wouldn't advise it as such?
well, it
Can I use Cake to do my will?
no. You can upload your will, and it'll have some links to places where you can do your will. But to do your will, you'll see in a couple of minutes there, I'm recommending other products. So again, some of it is just a repository for organizing this stuff, putting your contacts in and stuff like that. Others are links to some information to consider in that.
Who are these guys?
Cake.
Is it I mean, when you think about it, who are these guys? It could be Chinese, for all you know. It could be African. It could be it could be the mafia. Who knows who you're giving all this information? I mean, to me, it may be
you're putting it in a file.
Right.
So, well, again, if you don't trust it, you can do all the stuff manually. This just kind of automatically steps you through the stuff.
Lack of trust.
But it still would help you with the planning.
Yeah. You don't have to keep anything out there, but if you went through the steps and you figured out this is what I should do, even that's a benefit there. Okay. Now we'll go into some tips there. I use software, and actually I use this. It's called Willmaker 8, Nolo Willmaker 8. It's 20 years old, and it still works in Windows 10, which is amazing for a package there. Now you can't buy this, but you can buy Willmaker Plus 2019. You can find it on eBay and Amazon for about $45 to $80. So I'd highly recommend this. And this comes with a book that steps you through and does things too in that. And it does a number of documents in addition to what we talked about today. It does. Yes. Just like tax software, it steps you through. Well, here let's go through this video quick. This is a minute.
Protect your legacy and save hundreds on legal fees with America's #1 estate planning software. Quicken Willmaker Plus 2019 from Nolo makes it easy to create customized estate plans for your entire family. This powerful software for both Windows and Mac gives you the practical and legal information you need to make wills, financial powers of attorney, healthcare directives, and other essential documents. You can also create executors documents, documents for your home and family, and documents that provide important information to your caregivers or survivors. Complete forms at your own pace and have peace of mind that a team of lawyers has made sure that all laws are met for each document. And new for 2019, you can now use Quicken Willmaker Plus to create unlimited revocable living trusts. To get access to the trusts, just register your copy of the software. As a bonus, when you register your software, you'll receive subscriptions to NOLO's online promissory note and another document of your choosing. Make a plan that protects you and your family with Quicken Willmaker Plus 2019 from NOLO.
Yeah, so it is the TurboTax or that of the will software. It is the #1 package out there and has been around for, I don't know, 25, 30 years. So it's not just a fly-by-night deal. This was kind of mentioned a little earlier in the wills there. Mention if you're not going to give money to an heir, you want to expressly name them in your will, leaving that, so you put an example. I acknowledge that John Smith is one of my children for whom I make no provisions. You don't just want to leave people out of a will. You want to specifically say nothing for them. Yes.
There are state attorneys out there that say you shouldn't state it that way. You're supposed to give them a very specific amount.
$1.
$1, $1,000, something that looks like they weren't intentional. You shouldn't go to zero.
Well, basically what they're trying to get at is, as long as the person is named in some way, it's when you leave the person off, that's when a person will go back to the court and say, gee, this will was written 10 years ago. He forgot about me, or he wasn't in a state of knowing and that, and so I was just left off, so I should get an equal share. But regardless of exact wording there, you're best off to mention it. Well, not mention it, to be sure to list it. Another thing, don't include end of life or funeral preferences in your will. Put them in your living will and some of these other documents that we've talked about. Keep your will as clean as possible. Conditional inheritance can be a trouble, more than what they're worth. It may be worth paying an attorney to help with complications and contingencies to get what you want. But most lawyers won't do it, but I'm doing it. I'm saying don't put any contingencies in there. So a contingency could be something like, I'm going to leave you $100,000 if you graduate with a medical degree. Well, exactly what does medical degree mean? So if I go to this and I get this, does that mean that I get it? Plus, then somebody has to administer it, and so conditional, don't put conditional things in your will. Keep your will simple. Most people can get by with that. Yes. Right. Oh. Yes. Good point there. You want things to be crystal clear. Yeah. So you don't want to complicate these things. You want to keep them as simple as possible, and yet people will try and put in contingencies and things like that, and it just is not the place to do it there. If you have a pet, leave your pet and money for its care to somebody who will take care of it and who has agreed to do so. You don't put it in the will. If you want to formalize the arrangement to ensure that there's no misunderstandings, you can do what's called a pet protection agreement or pet trust. But don't put it in your will unless you want to piss off your relatives by leaving everything to the dog and nothing to them. Do not leave significant assets directly to minors. The court will appoint a guardian who will look after the assets and claim fees. And believe me, they will claim fees.
Every year.
every year. My grandfather left some bonds for myself and my brother and my sister, and the bank that was acting as the guardian there essentially took all the interest. So while we were below 21, they took all the interest. So, and if my grandfather had known that, he would have rolled over in his grave and strangled them to death.
Right.
But he thought he was doing a good thing there. No, you got to be careful of these things.
So Tom.
Yes.
So for education, the 529 plan is a much better way of doing it.
Exactly. There's other ways to handle some of this stuff, and that. But watch out if you think the courts are there to help you and the lawyers are there to help you. If you probably haven't heard, I'm not real trusting of lawyers in the court. So do the stuff yourself, specify the stuff, keep it simple. Consider tax planning and tax laws for larger complex estates. So in some cases, if you're trying to do tax planning, that's different than will, but it's certainly combined in there, because when a person dies, again, depending on how big the estate is, you can transfer that to the heirs there and not pay taxes. But if you just transfer, let's say, everything to the wife, and then the wife dies, and you're above the limit for the tax, all of a sudden you're going to get hit with huge taxes there. Whereas you should have transferred some of that at the time that the first husband or wife died. So there's tax planning things that can be done, but you do have to be aware of these things. And again, do you have to talk to a lawyer about your will? No, that's more a financial tax accountant to talk about how to pass this stuff on, minimizing the amount of taxes that you might have to pay there. This is an important point. Read the witness rules provided with your do-it-yourself will carefully and follow them precisely. So when you print it out or that, you'll get instructions on who can fill it out and how they should fill it out. Make sure you follow that exactly. Check out community education classes. This is like the St. Paul. They have classes in estate planning and healthcare decisions. So if you're unfamiliar with this stuff or don't feel comfortable searching on the internet or doing stuff, for $25, they have estate planning classes and health directive classes in here. They won't tell you how to fill it out, but you'll get all the questions and that answer. When changes happen, whether your marital status changes, you have new children, grandchildren are born, excuse me, deaths, you move to a new state, your property values change, your executor moves or dies, or tax laws changes, you want to make sure and write a new will or add a codicil to the will. Usually it's just as easy to write a new will and get that signed than it is to do a codicil, but whatever.
So Tom, what's the view on co-executors?
Again, kind of going back to what we have, you can have a primary, and then if the primary is unable to do the duties, you can have a secondary.
I went through this. Okay, so
yeah.
For my mom, when she died, I thought it was best to make me the executor. The problem is I live in Minnesota, she lives in Georgia.
Right.
My sister, who did all mom's bill paying, she knew all the finances and the rest of it, really should have been the executor.
Right.
So what we did is after my mom died, then we went, because it's a probate state, we went to an attorney, and she said, well, the way we should handle it is we'll make my sister an administrator. So I was still executor, but she was administrator, and she did 99% of the work.
That's the problem. If you got one person that lives next to you, but
right.
the older one, the one that most logically would be the executor, lives far away.
Right.
And you're saying pick one.
So in our case, we named my sister the administrator.
Because
even though
the
I was still the
closest there.
executor.
But you're also saying she was very competent too.
Yes.
So if somebody's not as competent as the other one, then how it makes it more difficult to decide. Follow what I'm saying?
Yeah.
But you're saying don't pick them both.
No, because again, you potentially can have conflicts of what to be done. So one person is the executor.
Well, what's interesting about that is my two brothers handled my mother's estate.
Well, I mean, if they can agree, that's great. But
well, they actually worked together where it actually helped them because one figured out something better than the other one. So I don't know. It can work. I know that.
Yeah. And yeah, if you're an executor and let's say the person hasn't told you and suddenly, you go, well, I don't really want to do it. You don't have to do it. And then it has to go down to the next person if you've named one. If not, the court is going to appoint somebody and then charge accordingly. So you don't want that. And again, this is where it gets back to trust, and you have to make that decision. It's a hard decision. Who is going to do it? Who is ultimately going to have that? And when you have multiple children, one person has to be responsible. Doesn't mean that one person can't talk to everybody else and say, what do you think about this or what do you think about that? But ultimately, it's the one person that has to sign the document that closes the estate, that makes sure that everything is going there.
And the executor can get paid for what
yes.
they have.
Yes. Yep.
So can the administrator.
Yeah.
And
yes,
Jim.
Jim.
We did pay money to my sister.
Quick question. You made reference to putting things in the safe deposit box. I've heard that upon death, that is sealed.
It is.
So my wife and I have a safe deposit box, and my son together, all three of us. Does that mean he cannot get in to get his passport out for whatever reason?
Yeah.
Yeah, he's on assignment. Okay.
Yeah.
That's the way it's sealed is that nobody's living that.
Right. Okay.
Yeah, the other thing with all these documents too is that's the original copy of the document that's signed. You want to scan in these other documents and have PDF files or whatever that I uploaded to Cake, that I uploaded to LastPass. Now everybody or my executor, and where needed, if I have to send this stuff into a bank or whatever, I can usually fax that in, send that in, because again, I have access. But if anyone challenges it and says, I need the original document, you have to be able to find that original document. Yeah.
If you are a veteran and you intend to use the Fort Snelling Cemetery or something like that, you should have a copy of your DD-214. If
Yep.
you don't have it, do a Google search on the DD-214, go to the National Archives. I just did it. It took about 2 weeks. You fill out the form online, you get multiple copies of the 214, each with a raised seal. The cost is $0, and they'll mail it to you in about 2 weeks.
And that's a very good point. You can do a lot of this stuff ahead of time so that your executor and the people won't have to be scrambling the day that you die. And my father is going to get buried out at Fort Snelling. And essentially, I've got it all ready. I've got it all ready that when he dies, I just file and it's done. I don't have to scramble at that point. So a lot of these forms and things like that you want to look up and you want to have available. The obituary, if you've got elderly parents, mine is 90, 92 and 88, we've gone through and made their obituaries already. I mean, you might as well.
Yeah, might as well.
Rather than, you get exactly.
So my wife and her sister picked out the casket for their mother, and she was there, and then one of the sisters says, "Well, Mother, get in there and see if it's."
That's a little bit. Oh, I'll quickly go over some of these.
We all got stories.
I'll quickly go over some of these. We're past our time, but Facebook allows you to put in a legacy contact for memorializing your account. You can put that stuff in. Again, if you saved your accounts and passwords and you've given it to the important person, they can still continue to get into your accounts and do stuff, which is a lot easier than some of these trying to prepare for the afterlife there. We mentioned list your digital assets and social media. Some people think that they own books, music, and movies. Those usually are not licensed to you. So if you have a library of songs that you purchased from Amazon, when you die, they're gone. They can't be transferred to anyone. This I mentioned, don't create hassles for your executor by not listing or providing accounts and passwords. So you want to make all of this transition as easy as possible, and so try and make sure that you document stuff, you put accounts, you put passwords, and this, you can set up some of these legacy, but as an example, like Gmail, well, I'm going to continue to have access to my dad's Gmail account forever. Well, that means that I can make some changes, I can use his accounts, I can get other information from that. I'm not letting that account be locked down when he dies, that kind of thing. And I mentioned here, don't close accounts until all the bills, assets, and taxes have been taken care of. Just makes it easier to have access to all these things than to lose access and then try and gain access to some of the stuff later.
Okay, done another tip?
Yep.
One of the first documents you should seek if a loved one died is the death certificate, because you need it for insurance and everything else.
And figure out how many copies you might need too, because
I need a lot of them.
Yes.
I went through this.
Yeah. Yes.
If you add a family member to your safety deposit box, you have to get another key for them. What if they don't have a key?
I'm not sure how that works. Does anyone know?
Yeah, let them know your
signature card, then they can go in and sign. If you give that, I want to give permission to my son to have access to our safety deposit box. So we've got 2 keys, one for myself, one for my wife. So we should request a third key. Is that how this
In our case, Hal, we didn't request an extra key. My son can get into our safety deposit box only upon both of our deaths. So, but he is on the records, so the bank can open the safety deposit box for him.
This is what I found that it ranked some of the will makers, and the best overall they picked Quicken Willmaker 2019, and I mentioned that it sells for $45 to $80. There are some easier to use. LegalZoom has a number of other legal documents and access to lawyers online and stuff like that. However, they do charge by the document. It can vary from $69 to $149, and that's per year. So again, that's why Quicken is usually better. If you want to try something free, there is Do Your Own Will, and that'll step you through creating a very simple will. Personally, I'd recommend spend the $45 by the Quicken Will Maker. And there's a site there, and it does have some other lists out there. Yep.
Now, one final tip I'm trying to remind myself is to be generous, because if you don't have the same amount of money as Prince, you don't have the same amount of problems.
And you give it away before you die.
Yeah.
That complication
And you can do a lot of money. You can give away a lot of money without any taxes.
Yes, and that's where, depending on what you have, but you do have to be aware of too, that let's say you don't have that much money and you want to start giving it to the kids, and then you find that you have to go into long-term care. If you don't have the money to pay for long-term care, the state or that can go back to those relatives and ask for that money back, going back 5 years.
It's up to 7 now.
Or 7, and so you have to be careful with some of that going on. So
One more tip, Tom. And that is, a lot of people don't think about this, but if you plan to have a funeral, try to chart out what hymns you want, who do you want to officiate, if you want somebody to talk about you, if you don't want people to talk about you at the funeral, lay that out in advance. It makes it a lot easier after you're dead for usually your children to figure out what that order of service is going to look like. Makes it a lot easier for them.
And along those same lines too, where's your address book? To contact people, whether it's to call them or stuff like that, because sometimes people don't know that somebody dies and they don't know, well, I know the friend Becky, but I have no idea even what her last name is or where she's located, or she may be down in Arizona, or so addresses and things like that, all this information, it's best to start talking about that stuff as early as possible. And especially like in my parents' case, we've had that hard discussion and sat them down and said, we just want to make this easier for everybody. Let's go through this and identify everything, and let's create the obituary, and do you want to be cremated, and where do you want to be, and stuff like that, and then you can get some disagreements. My dad wants to be in Fort Snelling. My mother wants to be at her family's plot. Well, can't have it both ways. So you have to figure some of those things out. But it's better to figure those out while they're alive, and then to wait and then have these discussions after.
But now I got a question. One problem. If you're picking the hymns, are you picking up the ones you like? If you're dead, who cares?
Well, if you don't care, don't pick them.
You pick the ones that are going to be there, right?
Yeah.
And the easiest thing for that, if you've never had to do that, is just usually they're going to friends' funerals and stuff like that, and just take the bulletin or the deal and program and figure stuff off of that. Oh, I like this. I didn't like this. I don't want to have this. I don't want it to be too long here or whatever. I went to one. I went to one 2 weeks ago or 3 weeks ago, and the service itself was close to 2 hours long.
Wow.
And I'm going. The guy's wife had died, and then one of their sons had died, and they combined it to a memorial. But they had 3 different. He's a singer. He sang Ave Maria. They had a couple of instrumentals with the kids, and then the kids were all talking too. And I mean, again, shorten it down.
20 minutes.
Well, I would have been happy with even an hour, but once it started going beyond that, it was kind of this. Ooh, okay. Yep.
That's why you still have that.
Yeah.
Yeah. When you buy at this point, Nolo was the maker of it. Now you have Quicken Nolo Will Maker 2019.
That's into it.
Or into it, yes.
Yeah, but it does still say recommended.
Right. That's that you own. You own the software. You can continue to use it. Now, are there some changes? Are there some changes over time? Well, this is an example here. State of Minnesota has a document. If you've ever been out to the state fair and gone by their booth, they'll have all kinds of booklets and that. It's worthwhile picking up. This is free of charge. Probate and planning, and it has stuff. And they have in here power of attorney document. Well, they had it in here, but they did make some changes. They have a new version. So, I mean, occasionally there are small changes there, but for the most part, a will is a will. A will hasn't changed in 20 years or 30 years there. And because you could have created it and signed it and that, you won't have any problem with it legally. Yes. The packages themselves. Here's Willmaker 8. That's
Yeah, I thought all this stuff
online these days, through some webpage.
Well, it depends. It depends on the package that you're using. That one free one is all online. You fill it out. This is software similar to TurboTax. TurboTax has the option of doing stuff online, which is a completely different version than the one that you run on your PC. So this is software that you run on your PC. So if you buy the Willmaker 2019. You load that on your PC. That's why it said it's available for the Mac and it's available for the PC. You load it, you own it. You can install it a year from now, 2 years from now, whatever out there. This is where it'll show you the different steps that you've gone through if you want to change anything, and it also has all kinds of help and legal information out there also. Yes, you just reload it. You just reload it. Now, if you bought the package online, what you do is you download the software, and then you put in the key or to activate it. If you buy it in the store, it's going to come with a CD or on that CD, it's going to have an activation code where you could download and do it. So the way that you load it or where you buy it is going to determine if you have a physical copy or what you have to do, but you can load it.
So I thought this was an excellent topic. I hope everybody enjoyed this. This was kind of unusual. Normally we're telling you how to watch for viruses and such, but I appreciate when this topic where we can use our computer to do something completely different. So,
Thank you.